Brian Kilmer, welcome to the DCQ podcast Special Sits. It took us a little bit of time to get this organized, but, we succeeded. How are you today?
I'm doing great. How about yourself, Peter?
Yeah, actually, not too bad. It's one of those beautiful days, and they're, once in a while they come by. Today is one of those spring day, blue sky and sunshine and nice temperatures. So, everybody has a spring in their step in London. But that is obviously something you're much more used to, right?
Absolutely. I come from the Northeast originally. I live in Houston now, but the Northeast, similar to England, as you start to get into the warmer spring and summer months, it's a lot nicer weather than the dark, cold winters. Although it's still dark here, as you can probably see over my shoulder here in Houston. But sun
Yeah,
should be
that's
up.
right.
Sun should be up soon, and it's supposed to be a pretty nice day, from what the weather folks say.
So you're joining us today from Houston, Texas, right?
Yes, sir. Yeah, Houston, Texas.
So, yeah, I was fortunate enough to see you a couple of times, on your home ground, because my oldest son has moved to Houston. But as you said, the start of your journey was really not in Houston in the South, but, in the Northeast, in New England, in New Hampshire. And maybe we can start the conversation there. How was it to grow up in New Hampshire? And maybe you can tell us, how, when, and why you sort of decided to get into law, and then obviously through law get into the special sit space.
Yeah, no, let me just, I grew up as you said, I grew up in a very small town in New Hampshire, called Wolfboro. It's right in the middle of the state, in what they call the Lakes region. So, lots of mountains, lots of lakes. It's beautiful country, very, great place to grow up as a kid. Both winter sports, summer sports. Um, Ultimately, and then I ended up coming to law school at Tulane in New Orleans. That's what brought me down south originally. And my first winter down here, I remember sitting on my balcony in January in a pair of shorts, having a cup of coffee, and I remember thinking, I don't think I'm going back to the Northeast. I did not miss the harsh winters at all. And so from there, I left Tulane, graduated from Tulane, clerked for a federal judge in New Orleans for a year after graduation, and then got recruited to come to Texas. And actually, that's where the restructuring part kicks in, I was essentially pitched by a very well-known bankruptcy boutique at the time. A boutique that is no longer in existence, but a firm by the name of Sheinfeld, Maley Kay. And it was a very well-known, in fact, one of their largest cases was they did the Dow Corning bankruptcy. So very well-known firm at the time. And they recruited me. Their pitch was, candidly, I was a big collegiate debater. Moot court was a big focal point of my law school career, Peter. So I was headed towards litigation, straight litigation. That's where I thought I would end up. But ultimately, they pitched me on the idea that, hey, if you like courtroom work, you like motion practice, bankruptcy is a really great area for litigators or people that like to do that, because our lawyers go to court more than any straight litigator. You don't spend as much time in discovery. You spend more time actually practicing law in front of a bankruptcy judge. And so I was a little resistant to that concept. So they ultimately hired me as kind of a slash lawyer, where I would do half litigation and half restructuring bankruptcy work. And I quickly gravitated towards the restructuring bankruptcy work. I found it fascinating on so many levels, very quickly, and very quickly realized I also did not want to be in Texas state court, which is affectionately dubbed the Wild Wild West of but backing up just for a second, I mean, what really got me interested in law, Peter, candidly, was my father was a police officer. My mother was a legal secretary, and so law and legal issues were really discussed around the the dinner table, the breakfast table, most of the time. And I guess eventually it just kind of sunk in that that was a topic I enjoyed and liked listening to and getting involved with. And then ultimately, while I talked about doing business or being business focused, law was kind of where I ended up heading towards. So, and obviously,
New Hampshire was not the state where you could pursue your career, or were there other reasons other than the weather that sort of brought you all the way south. Obviously Tulane is in Louisiana, so yeah, I guess getting into that university brought you there, but then yeah, you didn't go back.
yeah, I obviously joked that it was the weather, but it certainly was a factor. I can't say it wasn't, but yeah, ultimately heading back to New Hampshire, it's a very small state, not a lot of business. At least back then. It's grown a little bit because of some of the tax incentives. So I had considered maybe working in Boston, in Massachusetts, or maybe New York as well. But
Yeah.
yeah, I really fell in love with the South, and in particular, Houston and Texas in general is a really great marketplace for lawyers, and in particular, a great place for restructuring lawyers, especially these days, because there is a lot of restructuring work in Texas, both in the Southern District of Texas here in Houston, and in particular in the Northern District of Texas up in Dallas. So there's a lot of. It used to be back in the day that Delaware and the Southern District of New York were really the prime spots for filings. You didn't see the number of big business filings here in Houston or in Dallas, but that has dramatically changed. There's a lot of work here. So Texas really, I love New Orleans, but I couldn't see living there and working there either. But Texas was I think a really great opportunity for me, and I've loved living in Texas. So like I said, it's hard to.
And why is that? What is sort of because yeah, New Hampshire, you say it's an outdoorsy state. A lot of wilderness, but not a lot of business, but close to, I guess, centers like Boston and New York. What about Louisiana then?
Yeah, New Orleans was the same thing. Very small town. It really, while it's a city, it really the legal community is very, very small. I just didn't necessarily see a lot for me personally, a lot of upside for my practice. It's also a very insular city where who you know and who you grew up with is very important. Whereas being an outsider like myself, I'm not so sure that was a good place for me to practice law, Peter. So I never really focused on staying in New Orleans. And I thought, like I said, at the time, I just thought Texas was a really great option because there's so much business here, because, it's a big state. There's a lot of, I love sports. There's a lot of sports that comes through here. So just a lot of factors really went into the decision to come to Texas versus going back home. And like I said, some of it was the weather, some of it was, but most of it was really the opportunity. And Texas, candidly, I also weighed New York opportunities against Texas. And what I came down to also was the cost of living in Texas was much lower.
Yeah.
I felt the schools were better without having to send your kids to private school. And so it just, a lot of all those factors kind of weighed. I'm obviously a lot older now, but schools were a factor for my kids and for my family. And so coming to Texas and staying in Texas became a big reason for that.
And your dad being a policeman, so you didn't really venture into like criminal law, being like criminal defense lawyer or anything like that.
No, I really didn't. Some of the, I'd be fibbing if I didn't say some of the reasons why I became a lawyer, went to become a lawyer was for the financial opportunities. I grew up, again, working class family, that struggled quite a bit. And so I was looking for a career and opportunities that would hopefully, set me up in a better financial way than my family had been, Peter. So,
Yeah.
yeah, I never really gave criminal law, any interest. I was always interested in business law or litigation related type work, just because I found it more interesting. Um, Criminal law is pretty straightforward. I just don't know that for me was going to be something that I would have been all that interested in, notwithstanding the fact that we talked about criminal law quite a bit growing up. Um, But yeah, no, I just never was really interested in that aspect. It was always a business kind of or litigation type practice for me.
So then you got recruited in Houston in like almost like a boutique insolvency firm. So that was, you got your feet wet immediately. And that boutique firm was subsequently, gobbled up, I guess, by a much larger firm where you and I sort of met in the restructuring practice of Akin Gump, Strauss, Hauer and Feld.
Yeah, that's right. I mean, the bankruptcy world changed a lot during that late 90, 2001 timeframe. It used to be that, the so-called white shoe law firms here in the US really didn't do a lot of debtor work. I mean, you've heard of Weil Gotshal. I'm sure Weil Gotshal was and still is one of the premier, debtor firms in the country. And a big reason, if you read their history and look back on how they grew, because they grew because debtor work wasn't traditionally being done by the big firms. They just didn't do it. They did the creditor work, but they didn't do the debtor work. It was just considered not good work to be involved with. That's really, and that's actually why Sheinfeld grew for the same reason in Texas. They basically got referrals from all the big firms for debtor cases because the big firms weren't taking that work on. So in the late, I got out of law school in 1998. I clerked for a year in 99. So I moved to Texas in 1999. But by 2001, there were a lot of paradigm shifts. And that the biggest one for bankruptcy was that the big firms started thinking more about doing the debtor work and doing committee work and creditor committee work in particular. And the reason was simple. It's highly lucrative. I mean, highly lucrative. Debtor cases in particular can bring in millions and millions and millions of fees. And I think too many law firms just wondered why they were letting that work go. And bankruptcy had become a little more of a traditional practice and less of a kind of a bad mark on it, on that type of thing. So you had that happen. And then you also had the rise of California firms coming into Texas at the same time, and salaries for associates skyrocketed. So Scheinfeld was in a situation where all of a sudden, it had a really strong lock on debtor work in Texas and had a national reputation. And all of a sudden it's going to have competition, and that competition is going to come from where? Its own partners. A lot of the partners started getting heavily recruited across Texas. And the salary pressures for associates also went to partners. And I think a lot of them had great opportunities at different firms. And like you said, one of them was Akin Gump, which ultimately is where initially I think there were 6 of us that came over from Sheinfeld, including Mickey Sheinfeld, who came
Yeah.
over as senior counsel to Akin Gump. And there was a whole group of us that came from, like I said, I think it's 6 or 7. I can't remember the exact number, but it was quite a big. Sheinfeld was only 80 lawyers, 85-ish. So I mean, you're talking a pretty good size, pretty good percentage. So ultimately, those types of issues. There were others, but those two I think, were the big issues and the big reasons why that great firm, ended up getting gobbled up, and people moved to different firms, different opportunities.
So looking at the first reason, the attraction of debtor work and maybe, the unattractiveness of debtor work in the past, was that because the creditor clients were more important? And was it because that was initially primarily the banks, big institutions that were, clients of the firm, the white shoe firms, more generally also in other practices, and therefore in restructuring they sort of followed the clients, and do you think that also the fact that you know what is it? Private equity got more involved, and they, were maybe clients of the white shoe firms on the M&A side. But then when it goes, sour, they wanted to have their same firm doing, the debtor work as well. Are those reasons you think for, the shift that you saw, or why was it all of a sudden, something that that got the attention of the white shoe firms?
It's a great question. I don't know. I can't probably pinpoint one watershed event that just made this paradigm shift happen kind of all at the same time. I do think some of it was what you just described. I think some of the private equity firms started wanting more options for debtors counsel. I think my guess is that law firms, I mean, we know their businesses, right? We both own our own law firm, so we know it's a business, and you're always looking for opportunities to bring in more lucrative clients. And I think that's as big a factor as anything. That I think white shoe firms, I mean, I can speak kind of locally, but I think firms like Vincent and Elkins, who's a big Texas firm, it's no longer Fulbright Jaworski, but I think firms like that, Baker Botts, who are all old Texas law firm institutions, I think they all really looked at the marketplace and said, hey, we're missing out from these opportunities. I mean, like I said, debtor cases. I mean, I'll think one of the big cases that Baker Botts did in the early 2000s was a company by the name of Asarco, which was a mining company. And I mean, I think they made 100 and something million on that case. I don't remember the exact numbers, so don't hold me to the position, but I believe it was over $100 million. So I mean, the numbers to me tell you the reason more than probably anything else. Just because I think when you see some of these numbers that are coming out of these debtor cases, the large mega cases, it changes everybody's. It should change your mind to at least think about it. I also think bankruptcy had become more commonplace, right? I don't think it was. I think it was a niche practice for a while. I think it was somewhat of a it just was viewed as a practice that was a little squirrely. I think the code, obviously coming into an existence in the U.S. changed a lot of that because the rules became much more standardized. I think you also, around that same time frame, don't forget, you had Enron, you had WorldCom, you had a lot of these mega cases that were now filing for bankruptcy. So you had a lot more publicity to big bankruptcy related stuff, in particular, at least as Enron locally, because of the fraud that was involved in the situation. So it really was just a confluence of factors, Peter, I think that led to a movement for more big firm involvement on the debtor side. Like I said, I think when it really comes down to is money, but I think all the factors you just mentioned are definitely reasons why these big firms probably started the shift as well, because some of their clients, bank work is great if you've got a lot of it, but it's not as lucrative as debtor work, ultimately.
No. And again, maybe hand in glove with that is indeed the rise of this as a practice on its own, right? It's no longer just a bolt-on to corporate. It's no longer a bolt-on to finance. It's no longer, an aspect of litigation. It's something that almost stands on its own 2 feet. And yeah, I mean, look, the name of the podcast, Special Sits, when you and I started, that was probably not a term that was around, but has developed over time, and it encompasses quite a bit, and it's a specialty on its own. Because going back to maybe your Tulane days, how much bankruptcy and insolvency did you do in law school?
No, I never did. I mean, I simply really had never focused on bankruptcy as a potential practice area for myself. I mean, candidly, I went to Tulane because they had a great sports law program, which was kind of what I gave some thought to doing post law school, Peter. But ultimately, I really just decided to kind of head into litigation. I was lucky enough to get a clerkship for a federal judge, which, I've always said to any young lawyer I ever talked to, try to get a clerkship, because a clerkship is such a fantastic backstage pass to the law, as I always described it, because you really get to see the best, the worst of both, written product, people's briefings, and you get to see trials. You get to see how judges prepare for everything. You get to understand so much from that process. I didn't mean to go too far sideways on that. But no, I never took bankruptcy law in law school. I just simply never planned on going in that direction. It kind of fell in my lap. And, 25 years later, plus years later, I still love the practice, and I'm glad, thrilled that I'm still doing it, because it really is such a great practice area for so many of us that enjoy it. I don't know too many people who do our practice that don't end up loving it, because it really is a fascinating practice area.
It is, but obviously it's not without its challenges either. And to sort of for me, again, it's the same thing as you. I didn't do any bankruptcy related courses in law school either, and it's just luck of the draw that you sort of end up. My sort of supervising partner was. A restructuring and insolvency person, and that's how I sort of got introduced to the field, and it is a fascinating field. But so you started with a boutique, but then barely 2 years in, you're becoming part of a much larger institution. What was the experience with that? Because that's arguably speaking, that was not what you signed up for. You were sort of in a boutique firm, and all of a sudden you're in a much larger institution. Was that good, bad? What was different?
Well, what I would say was it was surprising, because I again, luckily for me, I was very fortunate to have that clerkship I mentioned, and the federal clerkships lead to a lot of opportunity. And so I was lucky enough to have a lot of options, including some big firms at the time I came out of my clerkship. But I really never wanted to go to a big firm. Even though I had some opportunities, I didn't really see myself at a big firm. I had always focused myself on smaller, kind of a smaller practice. In fact, I ultimately had always envisioned having my own firm at some point. So, I mean, Sheinfeld, when they came along and had both a local and a national practice, a great reputation, some interesting work, for me, it was a pretty easy decision. I really was pleased with the firm, and I thought it was going to be a great fit. And it was a great fit. I mean, the people were amazing. The work was fantastic. So, I mean, it just, unfortunately, the firm was in a tough position based on the change in the marketplace, the change in the salaries, that we discussed a few minutes ago, and people were leaving. And so I was one of those people that got plucked. The irony is, I used to joke, I don't want to go to the Akin Gumps of the world. No disrespect to Akin Gump. It was a very well-known national firm, and I had no intentions of going to a national firm. But what happened, at least for me personally, is watching Sheinfeld look like it's going to be in trouble, and watching the shift of big firms recruiting, and candidly, as a late 20-something person, there was a lot more money. When I was choosing between Sheinfeld and other firms, the difference between Scheinfeld's salary, even as a smaller firm, versus a big firm, was a very small margin. It was about 8 or 10,000. Just wasn't big enough. There wasn't that big delta between the two. Well, when salaries exploded in Texas because of the influx of all the California law firms, starting salaries went from low 70s to 115. And Sheinfeld couldn't, firms like Sheinfeld really couldn't compete with that. Understandably so. I mean, that's a big delta. So for me, the justification for going to a small firm also was it really wasn't a big difference in salary. Well, when you throw $45,000 on top, basically a huge number, which goes up, and that delta gets bigger each year, because Akin Gump would pay 115 starting, and you go up to 125 the next year and 135. And that was not the case at Sheinfeld either. So it was life-changing money from my perspective. So I had to make a shift to thought process about big firm versus small firm.
And what changed in your practice? Did your practice change? Obviously, you're part of a much larger institution, so there, good things and bad things about it. I guess they have a lot more resources, and but there's maybe also much higher demands. And depending on where you sit, in the U.S. in a national firm, were you in the beating heart, or were you a little bit outside? That makes a difference, doesn't it?
Absolutely. I mean, definitely working on different size cases. That's probably the biggest difference, I would say. Sheinfeld, other than Dow Corning, mostly was largely mid-sized type cases. Going to Akin Gump was a complete game changer. I mean, you ended up working on these huge teams of people on large cases. Akin Gump is, and I know you know, Peter, but for people viewing this may not realize that Akin Gump is one of the premier and has been one of the premier creditors committee bondholder firms in the country. I mean, they're in maybe not every large bankruptcy case, but a huge percentage of them, representing either ad hoc bondholder committees or unsecured creditors committees in mega cases like WorldCom, like Delta Airlines. I mean, you could literally go down a huge list of probably the 30 largest and see Akin as committee counsel on a significant number of them. So to your question, I mean, what changed was the size cases I was working on. Also, the location of the cases changed. Back then, most big bankruptcy filings were in Delaware or the Southern District of New York. So a lot of my cases that I was working on with partners in New York, and that were based in New York on cases that were in Delaware and the Southern District of New York. So I traveled a lot. That was one thing that really changed. Was I was on the road. I would work out of the New York office pretty frequently. It really was the size of the cases. Some of it. What was also great for me, for my development, I was very fortunate because I got to work with Mickey Sheinfeld a lot. I didn't work with him when we were at Sheinfeld at all, but when we were at Akin, I really got to work with him day to day, and he was a phenomenal lawyer and an even better man. And so I was lucky enough that I got the exposure to the mega cases with the New York folks, but on the local level, I was able to do a lot of small debtor cases. Not bigger cases, not too small, but maybe 10 to 25 million type cases. So I was able to get that exposure to the mega cases and get involved in these amazing restructuring efforts with these amazing lawyers from across the country. But at the same time, I was able to get the practical experience of going to court, of doing first day motions, of filing selling assets. I mean, I think I was a second year lawyer and I was an auctioneer on selling some IP. And so just very lucky because I got that balance that a lot of big firm lawyers don't get. And that's really because at the Houston level, we were still doing a lot of debtor work, even though the firm was largely focused on committee's work, as you know, Peter.
So it resonates with me a lot, and I wonder whether you felt being in Texas while maybe the beating heart was in New York, that you were almost like a local counsel for the New York team. Obviously, I was in the London office, which was something completely new that they had started. It was a new practice. They were nowhere yet, and I obviously started first, like 8-9 months in New York to get indoctrinated with, I guess, the culture, the practice, the clients, and what have you. But did you have to, qualify as a New York lawyer as well to be on those cases, or was it fine just to be, Texan lawyer?
No, I never had to get qualified in New York because we were able to pro hoc into the cases in Delaware and the Southern District of New York that I worked on. So no, I never had to, never really had to get admitted anywhere else. I mean, I'm admitted in Texas and Louisiana, of all places. Louisiana is a pretty strange. They use the Napoleonic Code, if people aren't familiar. So it's a very different type of practice.
It's like civil law instead of common law.
Yeah, exactly. Although, the interesting part about it, and I know we're kind of going off on a sidebar, but the interesting part that I always tell people is really it's not that different. Even though it's, the Napoleonic Code, it's civil law, the rules are still the same. Ultimately, the laws are largely the same as a lot of states. I think what's different is the language. So, for example, I think most lawyers have heard the term, or most people have heard the term statute of limitations. They don't call it that in Louisiana. They call it acquisitive prescription. So fundamentally, the substantive law isn't all that different, but it's a completely different language. And that at least for me, was the hard part. Studying for the bar, Peter, was that. But no, but back to your question. No, I never had to get admitted in New York or Delaware, but practiced there a lot, certainly in the early 2000s when I was at Akin.
But did you feel that you were sort of almost like, your local counsel brought in to sort of help the core team in New York? I guess, for English lawyers in particular, that maybe come from an English firm, move to a US firm, then all of a sudden, the beating heart is in the US, they're outside, and sort of, you're not driving the boat necessarily, you're in service of the headquarters. And I wonder to what extent you felt a little bit like that being in Texas, while, I guess the origination of the big cases was in New York. You worked on it, but you were not part of, I guess, the core New York team. Or was that actually not something that, in the States was a big difference? For me, obviously, being, not a US lawyer, but outside, and being in an outpost that was at that point in time almost nothing and needed to be developed. That was very much how you felt. But again, my background being a Dutch lawyer, I wasn't so it wasn't strange to me to be sometimes local counsel, but for English counterparts that sort of came, it was quite sort of, I guess, a shock to the system.
Yeah, I remember you and I talking about this many, many years ago when we were both at Akin. I never had that experience of being local counsel
Right.
for the New York office, and the only reason, there's a few reasons. One, I think I was still pretty junior, so I was really not in a position to be local counsel for anybody. I was really still learning to practice, coming up as a younger lawyer. But secondly, the reason I would say I wasn't local counsel is most of their cases were in their jurisdiction. I mean, it was in the Southern District of New York or in Delaware. We really didn't have any large cases that were in Houston at that time. It just was not a venue of choice for a lot of reasons. But it was not a venue of choice for companies, even that like Enron, that were based here. At that time, they went to New York or Delaware. So really, never really used as local counsel, used as kind of in the standard way you would utilize associates, which is, helping research items, helping write motions, take depositions. I mean, all those types of things. The small cases that I had mentioned earlier, really, I would say probably the only person I would say I would local counsel for would be for some of the Houston partners when they had, cases locally that they needed help with. But I was just really kind of a cog in Akin's amazing machine as a younger lawyer. And so I personally never felt that. I could absolutely understand why that probably was the case for you, though, on stuff in London.
But yeah, it was very early days in their, venture into the UK, and then I guess later on they sort of acquired the whole team of Bingham McCutcheon, and then that's a different story from sort of trying to organically grow things. And for me, obviously, it was a big change because I came from a Dutch firm that didn't sort of merge with Linklater's an English firm, and I sort of decided, well, look, my life is not going back to the Netherlands; is actually staying in London, and the opportunity to actually join a U.S. firm was great, and actually my time in New York was absolutely fantastic. Getting to know how to deal with new players like funds that at that time, early 2000s, hadn't really made the move across to, the UK and London. But that followed suit, and they have eventually replaced the sort of, clearing banks and relationship banks as the main players in restructurings. And yeah, you're sort of right there with an experienced law firm that deals with them stateside, and slowly but surely they all set up offices in London as well. And yeah, that to me is a huge change, looking back at 30 years of practice in our space. But I guess for you, was that also what you experienced, while you were at Akin, and obviously while you were still in, in Houston? Because well, you weren't in Houston, you were in Dallas, Houston, and maybe were you also in Austin? I don't know if that's the case, but you were obviously in Texas.
Yeah, actually, when I started with Sheinfeld, I was in Austin, and then when I joined Akin, I joined the Akin Houston office. And then after being at Akin for 6 years, they asked me to move to Dallas, and basically agreed to promote me or push me for partner at Akin Gump, which I obviously agreed to do, and I was fortunate enough to be promoted to partner at Akin Gump. So yeah, so I've bounced around a little bit, but I've still spent most of my career in Houston. I think ultimately I think it was in Dallas 6 years, and only in Austin about a year and a half. So, but yeah, so I've been largely in Houston.
But you are in the unique position to sort of learn the trade as debtor counsel, but ultimately those were not the cases that Akin was really pursuing. Going forward, you've also had real hands-on experience in large cases on the creditor side, and yeah, you went through the ranks and made it to partner in Akin Gump, but. You decided at some point in time that maybe the big firm and the sort of large case practice is not for you, or what was sort of the thinking at the time that you decided, look, I've had a good run at Akin, but I may need to do something else.
Well, I mean, as I alluded to before, having my own firm has kind of always been, was always my goal. I mean, that was kind of, it really was where I always saw myself. So, Akin was, as you know, we both know, amazing place, amazing law firm. The financial restructuring group, really put us in some amazing cases with tremendous experience. But I never really saw myself working on those mega cases, at least for much of my career. I've been very fortunate when I was at Sheinfeld, and then, as I mentioned, even while at Akin, to work on smaller cases from a debtor perspective, and really enjoyed that practice. And so,
And what's the difference, Brian? Because obviously you've seen both. And, sometimes if you're stuck in, big law, you will only see the large cases, and you just, gradually see all aspects of the cases. But in the beginning, you're just, one part of the bigger picture, but you may not actually have seen the bigger picture. Eventually you get to a stage where you see the bigger picture, but then the whole team needs to do various things, and you're coordinating as a partner more and more, but you also were hands-on on the debtor side in smaller cases. What's the big difference there?
I mean, yeah, I think the big difference, well, there's a number of them, but I think the biggest difference is in a smaller case, there's less money to solve problems. And so you ultimately really do have to, roll your sleeves up and look for restructuring options. You oftentimes have to be both lawyer and financially knowledgeable, understanding, because oftentimes these companies won't have the money to be able to have investment bankers and financial restructuring people. So, I mean, that really is the biggest difference between big cases and smaller cases. It's money. Most of the smaller cases still have the same issues: lack of liquidity. They have, problems with leases, or the business operations are struggling. And they have the same legal issues as big cases, whether it's a secured debt that's in default, whether it's, sometimes you'll have committees in these smaller cases, so you still have a lot of the same ingredients, but you really, at least in my experience, you really have to just completely submerge yourself into that restructuring because you don't have a full team to do it. And
And is it easier to get a compromise simply because the runway is shorter? There's not much money to go around. There's even more time pressure than when you have the luxury of some money there, and therefore you need to actually get to the core very quickly and come up with resolutions. Solve stuff as opposed to Um, litigate until the death, right? Or, argue until the death.
Absolutely. Yeah. Bet the company litigation's got to go fast. I mean, you don't have money to solve the problems. You can't kick the can down the road. Your statement is 100% correct. You know this because you've done big and small cases. So I'd love to hear your perspective on it. But I think that's the big difference I see is just you don't have the money to solve problems. So you have to find other ways to solve it. And whether that's out of court, whether that's in court, that to me is the fundamental biggest difference. And you just don't have a lot of help. You have to do a lot of it on your own. That's what's your take on that?
So is it also more, you're more directly involved with I guess, the entrepreneurs, the people involved, as opposed to in a large, restructuring, you're actually dealing a lot with other advisors, right? So you're sort of around the hoop, and it's all kinds of teams that are negotiating with each other, but you don't necessarily always see the clients behind it because, you need to be higher up in the pecking order to actually see the clients. But with a smaller case, and maybe a debtor's case in particular, you need to deal with the entrepreneur and the people that have skin in the game.
Yeah, absolutely. I mean, you're not only you're really the Lone Ranger in some ways. I mean, you're the person that's not just dealing with the entrepreneurs, but you're also, if there's a board involved, you're advising the board on what their options are, on what their fiduciary duties are. You're advising, then you're negotiating not just with one creditor in your little silo, like you would in a big case and you remember this. I mean, and I've worked at other large firms as well, but Akin in particular was very efficient about how they siloed off their cases, where you'd have the labor team, you'd have the bank team, you'd have the lease team, you'd have people that would do different aspects of the case. Can't do that in a small case. I mean, you don't have the personnel. You can do a little bit. I mean, if you've got litigation issues, you can have your litigation folks work on that part. But generally, you have to be forward facing with not just the entrepreneurs, but with the board if it's there, with all the creditors, in trying to negotiate. So yeah, there's a lot more. There's just a lot more of a global, for lack of a better term, a global work that you have to do in a smaller case as the restructuring lawyer. You don't end up just focusing on one aspect of it. You have to know the whole cap structure. You got to understand what the lease issues are. You've got to understand what the liquidity is. You've got to understand who the key players are all across the case, not just in your silo. So that's a definitely a big difference between the two sides, working on larger cases versus smaller.
So we're talking about like 2007 and then 2008. You sort of started, I guess, your own firm with two people that actually also were at Akin Gump. That was, at a time when I guess the world was on fire with the great financial crisis. Lehman fell, whatever. It was just the world changed. How was it then to sort of, start your own firm? And again, being part of a large organization and starting your own firm is two different worlds. I mean, obviously I did it, quite a little bit later in my career. And maybe when I did it, again, it was easier to do because technology had caught up and sort of, but you did it, right when the financial crisis hit. And running a firm, a law firm, is a different story from actually being a partner in a practice in a much larger institution, and you sort of, you have your blinkers on and focus on the matters. But here there's a whole firm behind it as well. To me, that was hugely eye-opening because I had no clue actually what was involved in running a firm. But I learned a lot from that. How was that with you in 2007, 2008? Because obviously you had the ambition already that you wanted to run your own shop.
In a word, scary. I mean, I mean, exhilarating, exciting. I mean, humbling. I mean, it's all of those things at once. Yeah, leaving the comfy confines of a large firm with, not just, steady salary, but also the all the staff that you have, all the amazing support that big firms have for, for partners, for lawyers, that make your life easier. You don't have to worry about accounting. You don't have to worry about collections. You don't have to worry about computers or operational issues. So it's scary for those reasons. I was lucky enough on that front though, that, and you mentioned that there were two folks from Akin. I was very lucky that they had actually already gone out on their own. So I didn't have to start from scratch. I mean, they had put together the systems in place. I mean, they had formed the entity, they had figured some things out. And yeah, to your point, the crisis and in that time frame was good timing to take that risk. But it was still scary. I mean, you at that point, you're at least for me in my career, I was mostly working for other people. I had some of my own clients, but not a lot. And my hope was that would, that leap of faith would hopefully lead to clients. But I didn't have a lot. I had some, but like I said, it wasn't enough to fully complete a practice. So we really had to build it from there. My two colleagues, Matt Oken and Chris Adams, they had one associate. They hadn't really grown yet. So I was still kind of early in, but I didn't have to start completely from scratch, which was helpful compared to, I think how you did it, Peter, but tell me if I'm wrong. But I think when you're going out just completely on your own, you don't have any of those systems in place. You're starting from scratch. I mean, that's
Absolutely. And
difficult. That's
that is
difficult.
scary in itself. It's funny because you and I spoke about, obviously the challenges of, having a shop that you run but also what you learn from it. But on the other hand, also, if you're young and you're in a large firm, you're always impatient, right? You always want to have things quickly, but in large, institutions, you also just need to have time, and the fact that you're working on matters that are not your clients, if you bide your time and sort of, continue to go, ultimately you're going to be senior enough, and then these clients that are firm clients or practice clients, you're going to be in charge of because you're going to be, the person. But as a young, lawyer, ambitious lawyer, you don't always see that big picture, right? You're very much focused on your own trajectory, and it always goes too slow, it seems.
For sure. I mean, look, I mean, one of the lessons I learned when I watched Sheinfeld, Maley Kay fall apart was that I mean, I hate to say it, but it's true that those partners that had business had lots of opportunity, and those partners that were essentially working partners didn't have a lot of opportunity. For moving on to a new firm, and obviously not a lot of mobility upside. So that resonated with me as I went up through the Akin ranks and was lucky, again, fortunate enough to make partner. What I was still concerned about at that stage in my career was, am I just going to be a service partner? And if I'm a service partner, um, how does that play out long term? Um, Short term, I think I was well liked at the firm. I certainly loved the firm. I loved the group, and I certainly never left for anything other than really the thought that I had more potential long term upside out on my own than essentially being a service partner at a bigger firm. That was my real concern, was long term. Where do I see myself? Do I see myself? The other thought process also was, at least at that time, after I moved to Dallas, I really wasn't working on very many local cases at that point, because at that point Mickey was gone. Most of the old Sheinfeld folks had moved on, um, and so I really was concerned that my career was heading towards really everything being in Delaware and New York, which, not a problem. I don't mind it. But if I'm going to build my own practice and have my own clients, which it's kind of tough to do when you're not actually meeting any clients or working locally in Texas. And so those two reasons were really my thought process at that time, Peter, was that uh, Akin, fantastic firm, great place to work, but long term, how is this going to work out for me? Am I going to continue to be a service partner for the rest of my career in Delaware and New York? I just didn't really have that as my vision for how I wanted to see my career go.
But okay, so you started there, and then I think you've been on a journey to, find the right setup to, do well, to enjoy the work and do it your way. And I think if I sort of look at the various things that you have done, and the sort of organizations that you've been part of, it seems somewhere a little bit larger. Then it was like, a venture into, again, another large institution, and now you're, I guess, it looks like you sort of found the size and the setup that works best for you. Obviously, things change over time, right? What is good in 2007, 2008 may not be, what is good in 2026. Can you say something about, that journey? Because, you started, Akin Gump, you've seen the big cases, the big law firms, you wanted to have your own firm, but that's not, that was not the firm where you've ended, right?
No, I mean, I've really vacillated between big law and my own firm. I mean, that's kind of how my career has gone. I think at this point I've spent about half my career at my own shop, essentially, and half my career at big law. Um, with a few bounces back and forth in between that time period. I mean, the short answer is sometimes the grass looks greener on the other side, and you get into a rut with your career or with your current situation, and you decide, hey, I think going back to the big firm might be the right path for me to grow my practice and uh, that's really the answer. It's just you're right. Your life changes. For me, my kids basically got out of high school and went to college, and I started thinking, hey, there's a lot of work here in Houston. A lot of big cases started filing here, primarily because, well, I think there's a lot of reasons, but I think one of them was that the judges were more receptive to some of the larger cases than the prior judges had been in this particular district, and some of the billing issues and billing rates, I should say, were somewhat issues for some of the earlier judges. So, I saw that happening where you had a big influx of mega cases, and as a small firm, you really couldn't capture a lot of that, or at least that was my concern at the time. And so I started thinking, okay, got kids in college or about to go to college. Not necessarily seeing a big uptick, even though there's a lot more filings now in Houston. And should I make a move? So I did. But fundamentally, I still like I like both worlds. I mean, that's I guess the best way to say it, Peter, is I sometimes sit there and I go, does big firm, is it the right move for me based on the timing in my life? And so I vacillated back to that a few years ago, and now after that ran its course for a number of reasons, I really felt like going back out on my own, like I had done for many years, was still the best place for me. Gives me a lot of flexibility. I don't have to deal with any conflicts, which is a big problem.
That's always,
Big
that
problem
is
in law.
one of the
Akin was amazing. I mean, you remember Akin was always really good with their restructuring group at managing conflicts. Um, in particular bank conflicts, they were very, very efficient. And part of that was because their group was so incredibly profitable and successful that they had the power to um, dictate some of the issues around conflicts. That's not the case at other large law firms, as I've learned, who shall remain nameless.
Yeah. No, and actually, it's interesting for people that look at large law firms. Uh, um, I think it is important to see where in the pecking order the financial restructuring, the special situations groups sit. And because, that will make a huge difference whether you get the support on conflicts, on actually, progressing the practice, on, maybe doing things that are a little bit off the beaten track. I mean, one big thing that obviously you learn from a large law firm is also how your colleagues view your practice, right? Whether or not, because we're talking a lot about, the clients being in denial and waiting too long to involve us. But, the same, unfortunately, still applies a lot of the times with colleagues, especially in large law firms, who should bring you in much earlier and don't do that. So maybe we can, move to something that I'm actually quite interested in. Is you obviously saw the development of Texas as a jurisdiction that is on the map much more for special situations. You were just describing, the influx in larger cases, the influx of, Californian firms and sort of white shoe firms in Texas for special situations. And obviously, at a certain point in time, there was the Texan two-step that became very prevalent. Maybe you can, say something about that development and exactly what the Texan two-step is all about.
Yeah, the Texas two-step really just involved mostly surrounding mass tort liability cases where they essentially do a spin-off of all the liabilities into an affiliate, subsidiary, depends on the structure, but ultimately just to an affiliate, and then file the affiliate for bankruptcy with the ultimate parent essentially backstopping the potential payment to those mass tort creditors. So instead of filing the main entity, they essentially spin it off, put all the liabilities into this new entity and file that. That's really what it is. Has not been well received. And I think Johnson and Johnson has tried it 3 times, and it's been dismissed each time. But it's an interesting idea. It's certainly very creative, and I think I understand. I mean, there's debate obviously out there on the two-step among lawyers. Some lawyers think it should absolutely be able to be done that way, and is actually beneficial to the tort claimants. And unfortunately, it just hasn't been universally received, and so it's been hardly fought, very, very hardly fought at the various times it's been done. But that's basically what the two-step is.
Okay, but that hasn't impacted on Texas being, one of the venues for larger restructurings.
No, because in fact, the Texas two-step's been used in many different places, but in particular, it's been tried in New York, tried in Delaware, and now tried in New Jersey. So, I think it was New Jersey. Forgive me if I could be wrong on that one, but it's been tried in other jurisdictions. What's really impacted here, at least as to Houston, which became a big venue, or I want to say 2016, 17, but the judges turned over, and you had Judge Isger and Judge Jones, who were widely regarded as very good judges, which they are, very good judges for debtor cases. And so, in the end, people are always looking for venues that are favorable to debtors. If you're looking for, if you're about to file a case and you've got venue options, you look at those venue options, and oftentimes one of the factors will be Things like, well, is this a good venue for us for this particular issue? If there's a specific issue involved, what does the Second Circuit say about this? What does the Fifth Circuit? But on a more practical level, sometimes it's as simple as the Delaware judges do lots of cases. They're really, really good, and let's just stay in Delaware. Sometimes it's, hey, the judges in Houston are really good. Let's file there. So it because I think the judges were viewed as very favorable judges, as good judges that moved quickly, that acted quickly, and would push cases through and approve cases pushed through very, very fast. I think that led to a serious influx of cases here in Houston. And I think that's true now in the Northern District. I think the judges up there are excellent, similar to here, are excellent. Now we've got Judge Lopez and Judge Perez on the bench. They're both excellent. They're both very sophisticated. And again, they act quickly, they make good decisions. And so I think because you've got that both in the Northern District and the Southern District, it's led to a lot more cases getting filed through. I mean, just backing up, I mean, when I first started practicing, like I said, from Houston was not considered a good venue. Almost no large cases filed here. Enron filed in the Southern District of New York. Calpine filed there. These are local Houston companies that did not file here. Dynegy didn't file here. Now, those same companies would definitely consider Houston, I think, as a viable venue to file that Chapter 11 and not just run automatically to Delaware or to the Southern District of New York.
So you think that it's a people's game? If you can attract, judges that have a good reputation and that work well and have the confidence of the market, your jurisdiction will be one of the jurisdictions that they're going to look for.
Yeah, I think that's true of most jurisdictions. I think if the judges are viewed favorably in the marketplace by the big banks and then also by debtors counsel, I think you've got a chance for your venue to be utilized. Obviously, you have to have that venue as a particular option, although people are getting more and more creative about creating venue. There was a big decision that just came out out of New Jersey, I think it was, that about essentially just putting money in a local bank for one of the affiliates is enough to create venue for that particular company. And once you get one company in, you can hook all the others in. That's been case law down here for the Southern District for quite some time as well. So that's not a new one to me, but I know that got a lot of publicity because if you can do that, obviously you can creatively figure out venue anywhere if you really want to be there. So yeah, if you've got a good group of judges or a good judge, it's certainly possible that you may have venue or opportunities to put it in front of that judge.
And I think sort of extending that a little bit more, I think outside of the US, the UK, Europe, have looked, and Singapore, for example, have looked at the US, have looked at the success of the Chapter 11, and have come up with, I guess, tools in their toolbox that can compete with the Chapter 11. And then all of a sudden, as you were saying, like, the forum shopping that is going on doesn't only extend, within the US, but also outside of the US. And, you and I sort of exchanged some information about that recently, that, there's the Texan two-step, but you have also, some call it the international two-step or the, Thames two-step,
Yep.
which is really, the similar, a similar approach towards trying to find what you need, and if it is good for a restructuring, and you can get it, across the line, that is what you need to do. And international two-step or the Thames two-step is really, you're finding jurisdiction, for example, in the UK to do a restructuring plan there, because you can change the law of your debt documents, or you create an extra obligor that sort of assumes obligations of the US parent, and you can do your restructuring outside of the US avoid having to go into a full-fledged Chapter 11, and then use, I guess, the Chapter 15, the US Chapter 15, as a way to get it recognized and get like relief in the US, so that actually whatever you do outside of the US has, effect in the US without actually using the Chapter 11 tool in the US. So I guess, your competition internally has now expanded outside of the US. And, we see more of that too, right?
I mean, first off, I prefer the Thames two-step name because I think it has more catch to it, more curbside appeal, so to speak. So I mean, look, I think the Thames two-step is similar to the Texas two-step. I mean, it's another creative way to get around a problem, a perceived problem. Now, it'll be interesting how wide. I mean, I think you're going to see more of it. There's no question. I mean, the question is how far it'll go, right? Where in this instance, they had near universal creditor approval and everybody was on the same page and singing kumbaya, so to speak. But it'll be interesting to see if the Thames two-step works when you've got a situation like the Texas two-step, where you've really got a creditor body that's fighting this tooth and nail, and whether this particular process can be utilized like that in that type of situation. I don't know the answer to it, but I'm sure, given that what's happened in situations where you need a restructuring like they did and I forget the name of the case.
What was it? Was it the fossil case, right?
Yeah, awesome.
Or are you talking about? Yeah, so
Yeah,
the Texan watchmaker that sort of successfully did this, Thames two-step.
So I mean, we'll see if others are able to achieve what Fossil did, simply because. But in a situation where you've got a creditor body that's largely supportive, it should work. I think that's, again, just another creative way to get around some of the perceived problems. And obviously the big perceived problem is third-party releases, and courts are getting less and less willing to agree to those. And so this has been set up as...
Maybe you can sort of expand on that a little bit, because that is all, derived from the Purdue case, right? The Sackler family, Oxy, the crisis that you had. And maybe you can sort of, explain what the issue is and, why, it may be an issue going forward that could be challenged to undermine, a contentious Thames two-step.
Yeah, I mean, third-party releases, all you didn't really used to see them that often, candidly, or you did, but they weren't as controversial because you weren't always releasing as broadly as they do today. But in that particular situation, you're right. Purdue was a Supreme Court case that essentially said you cannot do third-party releases and without consent. I mean, that's the basic gist of the opinion. And now the courts have gone in all different directions on that, the lower courts, I mean, about whether you have to opt in or opt out. But the long story, the basic gist is, a lot of when you have a big filing, in particular mass tort cases, what most anybody involved in that, in the case like that you just talked about, the Sacklers and Purdue, it's not just the company that wants releases, it's all of the insiders. And the company wants it for those insiders because it's another way. If you don't get those full releases all the way through, at least the argument is, if you don't get those releases all the way through and to everybody involved, it's just going to create a cyclical situation that never really gets resolved, because the company gets released, but they're still going to sue the family. The family's going to come back to the company to seek, money from the company.
Yeah, subrogation claims, ricochet claims.
Exactly.
They're just saying, look, we're paying on your behalf, pay me back. But we're just restructured. Yeah, okay, well, I'm going to file again, right? That is the whole reason why that sort of, third-party releases are deemed, at least in the UK, necessary sometimes, to do restructuring. Therefore, it's not so controversial.
Yeah, but that's what they're trying to get around with the Thames two-step, right? Is they're trying to get around
Yeah.
this prohibition or perceived prohibition of third-party releases. I mean, again, restructuring community and restructuring lawyers are creative by nature. So I admire the Thames two-step because I think it's an interesting way to sidestep this entire quagmire of third-party releases, which really has become a very difficult issue because every jurisdiction's treating it differently. I mean, some courts are saying, "Hey, yes, we'll approve them, but only for creditors that opt in." Other courts are saying, "Okay, we'll approve it, but they have to opt out." I mean, so give them the opt out rights. I mean, the creditor can opt out into and can opt out of the third party release, I should say. So it's a real it's very different across jurisdictions, and I think it's wreaked the issue in particular has wreaked a lot of havoc over cases that aren't as critical for third party releases. I mean, I do think I personally don't fundamentally have a problem with third party releases. I just think that ultimately you don't need them in most cases. I think they're overutilized. And people get all up in arms. Well, if talking with insiders, right? If you're a company person, you obviously want third party releases as part of your plan. So the companies want it. So the attorneys have to push for it. But a lot of times it's not really necessary. There's no real threat out there of litigation against officers and directors or affiliates related to these types of claims. To me, it's a issue that shouldn't come up in a lot of cases, but still does, simply because companies want protection. They want, like you said, they don't want to have to deal with a potential claim coming back around against them individually that then can undermine.
But do you think that it's actually a threat to the Chapter 11 practice that if there is no clarity on this issue and maybe on a couple of other issues, the fact that you need to do a full on restructuring of everything in Chapter 11, while with a restructuring plan you can identify a piece of the capital structure and do the restructuring without filing everything. Ultimately there's also a little bit of competition between, I guess, jurisdictions about where our big restructuring is going to be done. So, your Chapter 11 practice may turn into a Chapter 15 practice, but maybe that's, a lesser practice to have.
Yeah, I mean like always, right? Restructuring and bankruptcy morphs from different concepts to different things, and this may be a situation where, like you said, we get involved on a U.S. level in more Chapter 15s than Chapter 11s. I don't think it's going to go that. I think this is going to get ironed out at a lot of these courts about how they're going to do it, and it'll ultimately, I think, go back up for the issue of whether you can do an opt-in or an opt-out. And I think the Supreme Court will make a decision on that, but we'll see. But fundamentally, yeah, I think if the Thames two-step becomes a much more standardized way of getting around this issue, it won't shock me if there's a huge influx, a huge increase in Chapter 15s versus 11s. And I think you'll see a lot of new entities being formed in England.
But you don't see it as sort of like, an abuse of Chapter 15 because you're actually, avoiding using the quote unquote proper tool that you have, which is Chapter 11. But again, you see it all the time. Other companies from all over the world venture into the US, don't use their local insolvency proceeding because it doesn't result in what they need, and there's no issue with that, right?
I mean, I personally don't view it as problematic. I don't think going back to the concept of allowing an entity to create itself in one state and put a bank account there, which that creates potential venue. If that's allowable, and I think most courts have allowed that, I don't see this as any different. It's really just trying to find a creative way to find a venue that gets around a perceived problem. So, I mean, I think it's creative personally. Now, it doesn't mean that I'm going to like it every time. If I'm a creditor, if I'm representing a creditor, I mean, I might object. But I mean, to me, that's a little different than what happened here. This was a pretty consensual deal overall, and I do question whether the temps two-step will be viable in cases that are highly litigious. I'm not so sure it's going to work, but time will tell.
Yeah.
Time will tell. I
Yeah.
Candidly, I thought more judges would have more issues with the bank account creating venue. I really did. I'm surprised that more courts don't have a real issue with that. But I think venue shopping in the bankruptcy world has become more and more prevalent, and I think more judges aren't as offended about it as they used to be back in the early stage of my career.
What would the issue be? Because again, if you change the governing law for the purpose of creating a connection with a jurisdiction, then you're doing it for a specific purpose. It wasn't there historically, but it allows you to restructure. I mean, I guess it's the same with allowing. A payment to be made in a jurisdiction and create jurisdiction there, right? You need to have a view on whether you can form shop something like, insolvency tools, yes or no.
Right. And that's what I'm saying. I think 20 years ago, 25 years ago, when we first started practicing, I think more judges back then would have said no to that type of concept. I just think these days, judges and bankruptcy lawyers are less offended by creative venue shopping in that type of way. I don't know. Like I said, I'm kind of torn on it. I tend to think that we'd all be better off if there was more limitations on venue overall. But who's to say what's the right way to do venue? I mean, if you talk to somebody in Delaware, I think they'd tell you, well, it should be limited to where you're incorporated. But
Because everybody's incorporated in Delaware.
Their business would triple inside of 6 months. But whereas somebody like myself would say it should be a little broader, but I also tend to think that blatant venue shopping by setting up an account is not something I'm a big fan of. But obviously, the judges have been largely okay with it.
Well, if it results in a restructured company and saving businesses, avoiding value destruction, that ultimately is what we're trying to do, right? And whether you can do it in the U.S. or outside of the U.S. with the benefit of restructuring recognition in the U.S. I guess it keeps everybody on their toes in terms of having appropriate tools in their toolbox to deal with financial distress. Globally, I guess, that's a good thing, or at least that's what cross-border insolvency lawyers will say, right? It's sort of, very much focused on universalism as opposed to territorialism and competition between jurisdictions and venues.
I mean, look, I'm of the opinion, at least as to different venue options. I mean, I think having multiple venue options is important. I mean, I think it is. I just do. I in particular, I mean, if your perception of a specific jurisdiction, like here, used to be that it was not a good place to file debtor cases, I mean, you should have other venue options. I completely support that because I do think it makes sense. I think there are times where it would be better, if Delaware's swamped and you need a fast case, you may not want to go to Delaware and have that be your only place because you can't get your case restructured, your company restructured on the right time. Same with here. If Southern District is underwater, you should be able to file in somewhere where you've got principal assets or where your operations are. I mean, I think having that ability makes sense. Like I said, the question mark is how far can you go to do that, and what.
Yeah.
I've always believed kind of in the principle on all these types of topics, Peter. There's a famous phrase in the Fifth Circuit case, pigs get fed, hogs get slaughtered. And obviously what that means is I think there's things that, you are probably okay in this department. And I think when your intentions are good, like you just described, which is get it in a venue that makes sense because we think we can deal with this issue more effectively, I think that makes sense. I think that's a pig. I don't think that's a hog. I think where you're doing it for other reasons, then there's a question mark that we're doing it because we want to get this specific issue. You could argue that you're trying to get around an issue in a way that's more hoggy than piggy. But it just depends on the facts of the situation.
So you were talking about, special sits lawyers being creative. And I think one of the things that we're seeing these days a lot more of is liability management exercises, which again, is trying to be creative in many ways. And on top of that, I think, there is a lot of talk these days also about, shouldn't we have more ADR mediation, or people coming in helping resolve issues before you do it full-fledged in litigation in court? What are your sort of thoughts on that? And have you seen that trend also in Texas? Clearly, you've been anticipating things because you've sort of, positioned yourself as an accredited mediator, to be available for these situations.
Yeah, I mean, I think there not only has been an uptick in mediation in the bankruptcy world, that more judges are ordering it automatically as part of their procedures. It never used to happen that way, but I think in particular when you have cases where they've got a litigation trust that's been established and they expect hundreds of preference claims or fraudulent transfer claims, what have you, to be brought. I think more and more judges are putting it in the plan or putting it in an order separate from the plan that establishes that mediation will be had in all of the cases that are brought. So yeah, there's definitely been an influx of that in a lot of these larger cases where you're seeing judges impose mediation in preferences. And so yeah, I anticipate that personally to get even more prevalent. I think you're going to see a lot more, and I will tell you, there's a lot more mediation in bankruptcy in the main cases, ignoring the litigation, but in the main cases here in the Southern District, probably in the last 7-8 years, than I'd ever seen before. Down here, what the judges often will do is they'll get the other judge that sits on the bench to mediate one of their cases, and they swap back and forth, which is a really interesting way of doing it. Cuts into my business, but that's okay. It's a
Well, I mean, it's an interesting point. Do you need a judge or a former judge to do it? Obviously, if you are one, you'll probably say you need to. But isn't just an experienced practitioner somebody who can equally well perform that role?
Yeah, I mean, look, I've always been a big advocate for ADR, for mediation, in particular, and arbitration. Arbitration is, in my mind, very similar to bankruptcy litigation. I've been involved with arbitrations. I've tried cases in arbitration. I mean, it's a bench trial. It's fast paced, very similar to how bankruptcy trials work in litigation and bankruptcy. So it's a very, very interesting to me parallels between the two. But as to your question, I mean, yeah, I think mediation and having somebody, first of all, I don't think you need a judge. That's my own opinion. I think sometimes judges obviously carry more gravitas. People are more likely to behave, are more likely to be reasonable. Sometimes because if you're mediating with a judge that are in the same district, they talk. Ultimately you're going to get some feedback. So I think there are some cases where it's beneficial, absolutely, to have a bankruptcy judge. But sometimes bankruptcy judges, they're busy, especially these days. They may not have a lot of time. They obviously come free. So that's a huge benefit over doing a private mediator. But look, if you can't get a judge and ultimately, our judge doesn't have time or whatever, I think mediation and having somebody who has tremendous experience. I mean, there's one local mediator that has served as mediator in several of my cases. And I mean the main cases, not just the preference stuff, who have helped us reach resolutions on how to restructure a company. And so I absolutely believe that, that there are some tremendously talented non-bankruptcy judge mediators in the bankruptcy world who can oftentimes bring some sense of creativity to the process, maybe look at things a different way or get a party to look at things a different way, and can really benefit.
And what are their qualities you think that sort of stand out for somebody who actually is useful for that for that kind of roles?
I think it's somebody who's experienced, obviously, who's done a lot of restructuring, and somebody who's done restructuring from different sides. I think the best mediators that I've seen that do that are ones that weren't just debtors lawyers or weren't just committee counsel or weren't just secured lenders. They're ones that have worked on all sides, and
Yep.
have and understand what each side is trying to accomplish and why they may be opposed to doing it this way or doing it that way, and understanding what the key kind of pressure points are. I mean, I'm thinking of one person in particular who's just fantastic at that, and like it's the same person I've used a few times, and I think that's because her experience is remarkable. And she's really, really knowledgeable, and she understands the process from bankruptcy from beginning to end, and not just from that one creditor side or that one debtor side perspective.
Well, maybe just taking one step back. So, if you look at our space, special situations, special sits lawyers, is there sort of like a prototype for a good one and a bad one? What are characteristics that you should have or should not have based on your experience?
I I think curiosity probably, wanting to learn, wanting to learn about a company, wanting to understand what the issues are, digging into those issues, and then utilizing your experience and whatever research you need to do to come up with the best path for whoever you represent in that particular case. So for me, it's I will speak for myself, which is and really say why I like it and why I enjoy it. I think every case is different. Every restructuring that you do is different. It's always a puzzle. There's always n- it doesn't, even if it's the same industry, even if it's oil and gas or if it's this industry, every case is different within those. There's always a slight tweak. One's just operational, one's financial, one's both. There's always something unique about every restructuring. And so I think curiosity and wanting to understand how to put that puzzle together, and then having the knowledge about how to push the leverage positions depending on what those issues are and what bases you have. I think that really is fundamentally the most important thing. Curiosity and really tenacity to follow through on understanding those issues. And then, you know, I also think you got to be reasonable in the restructuring world. And I mean, while we have a duty, to zealously advocate for our clients, I think that also means that you need to be reasonable, because restructurings are almost always done collectively as a group, no matter who is representing who. And I think ultimately, if you're not a reasonable person, it's going to be very hard for you to achieve what you want to achieve for your clients. Because I think in our business, I think once you get a reputation for being too difficult to deal with, then the likelihood that people are going to work with you on getting a consensual deal done dramatically goes down. So I think
Yeah.
those are the things that I tend to think of. The best lawyers I've ever seen, um, are ones that are tough, reasonable, are always curious and always digging to understand the case, the issues, who's trying to get what done. But ultimately, I think you have to be a deal maker. I think it's great to have your litigation hat on, and be thinking of what your rights are. But I think bankruptcy is about cutting deals. That's the way I view it.
So what is then a successful result? A successful case? Is there, a sort of definition for that, or is it also very much case by case basis?
I mean, personally, I think the goal in every case is to avoid bankruptcy. I mean, I don't think bankruptcy helps anybody ultimately, and I do probably most of my work is out of court restructuring at this point, um, bec-
Okay.
because I try to, and I think, like I said, every time I come in, my goal, and I explain this to my client, is to avoid having to file this case and try to convince your creditors to work out a reasonable resolution so that we don't have to file. But I mean, that's not practical sometimes. Sometimes you have to file simply because you can't negotiate a lease or you can't negotiate with too many creditors. It's not practical and it's just easier and more straightforward. But to me, that's the goal. So I always view I'm most successful when I've helped the client restructure out of court, Peter, and successfully out of court and avoided a filing. That to me is the ultimate achieve. That's when I feel like I've really successfully done my job. As far as what's most successful overall, I mean, your fiduciary duty for a company, if you're representing the company, is to maximize value. So, I mean, ultimately, if you've gone through that process, you've maximized value to stakeholders in cases where you've gotten a full payment plan done with your creditors. Maybe it's full payment, but over time. I mean, that's a great result for creditors. I mean, for example, I did a staffing company that we unfortunately did have to file a few years back, and it was related to claims. The company is a staffing company that was involved with providing staff for the cleanup for Hurricane Harvey, and they essentially couldn't pay people on time because people were spread out and everything was destroyed. And so a group of creditors sued them under federal labor laws for back pay and penalties and all that. And so for me, that case, we ultimately did have to file a Chapter 11, and we reorganized in a full payment plan to all of those creditors. And I think that to me was a tremendous result. It was exactly, we stopped the litigation. We give the company some time to kind of figure out what they could do. And ultimately was able to put together a full payment plan. And I think that's a great result when you can do that. So back to your original question of when do you really feel like you've gotten a good result? It's most of the time it's when I've been able to help a client avoid bankruptcy, or if we had to file a full payment plan and that the company many years later is still doing well and surviving. That always makes me.
It can be rescued. You
Yeah.
survive it.
Yeah.
And do you think that because a big thing we sort of touched upon it earlier seems to be that funds have taken over the position of banks. There is obviously out of the US all of that. There is much more of a secondary market in distressed debt in a number of jurisdictions. A number of other jurisdictions, like especially in Africa, very much still a struggle to get it off the ground. And you see in a lot of jurisdictions, it's family businesses, it's people that are inadvertently in a situation, not professionals that do this for a living. Is your experience that you can get more done when you got professionals involved and you're not dealing with, I guess, a family business where there's sort of reputational shame and what have you, or original creditors who just don't want to be there, and if they could step out and move on and have, I guess, others buy up their claims, there's more to be done? Or do you have different experiences?
It's hard to paint with a really broad brush on that question, Peter. I mean, I think, I've had some more difficult times with traditional banks. Sometimes I've had some difficult times with private equity, hedge fund lenders. Um, Candidly, the ones that I think are most difficult right now, at least in the kind of the mid market, small market restructuring, is the MCAs and factoring agreements. A lot of companies these days are trying to find ways to liquidate their AR, and use that, essentially ongoing receivables, rather than just using a traditional bank. And so what they have done is entered into either merchant cash advances or factoring agreements, which in a lot of instances have some really onerous terms, fees, and uh, courts have been heavily critical in a lot of cases about some of the fees, and that notwithstanding the fact that it's supposed to be an asset sale, it looks more like a security agreement that has interest rates that are pretty high. And so while companies start out with these trying to find ways to enhance their liquidity, I think unfortunately what they oftentimes find themselves in is a very onerous agreement, that cuts into really their profitability. And so there has been a lot of litigation involving factoring companies and debtors, and I think we're gonna continue to see that because so many small companies are using factoring agreements and merchant cash advances to fund operations, and due to the terms, they're just
Yeah.
difficult. They're going to be very difficult.
Yeah. So AR, accounts receivables, for people who don't know
Sorry,
the
yeah.
abbreviation. I think another aspect that we sort of touched upon earlier, you were saying, look, I really enjoy, being in the special sit space still, almost 30 years on. But one aspect that, is a challenge is that it's always high, time pressured, and it's not a 9 to 5 job, and it can take over your life. How have you been able to deal with that, and how do you manage that so that you can still, after 30 years, enjoy what you're doing?
I have an amazing wife. That's the real answer. Um, I mean, yeah, I kind of joke about that, but I really do mean it. She is very understanding and patient when issues like you just described come up in our world. I mean, and it happens a lot, absolutely, where you'll get a call on a Friday and company needs help before foreclosure Tuesday. So you've got to ramp up that weekend and get a filing prepared for Monday. So it happens a lot. And I mean, it's just something. I mean, I was just talking about this with a friend of mine, an ex-colleague, about I do travel a lot, and like most people, take some vacations, but I don't think have had a completely um, free week where I didn't at least have to respond to some emails or have a phone call in 5 years plus years. I mean, you just always have something that comes up. And that's why I joke about but I mean it, but I joke that having a patient wife, because, she knows that even though we're on vacation, I may have to do some work. And that's just the reality. And it's even more of a reality and you know this, Peter, when you have your own firm, a smaller firm, because you don't have, a big room in the back with lots of associates and paralegals and people that can handle stuff while you're out. So I mean, that definitely a negative of kind of being on your own or having a small firm is that you lose some of that flexibility. But you know what? I don't mind it. I actually sometimes, I mean, people always ask me, when are you going to retire? Me? I like to work, so I'm can't see myself retiring. So I don't mind picking up the phone or jumping on a call or answering emails, even when I'm on vacation. I don't mind working nights or weekends when it's necessary. The one of the best things about having your own firm, and I'll bet you can relate to this, Peter, is sometimes you don't have to take on a new matter if you don't want to. It just depends on whether how is it an
Yep.
interesting case? Is there money for a retainer? I mean, things like that come into the picture much more so when you're on your own. Yeah, I mean, how do you deal with it? It's honestly, I think some of it is just if you're comfortable working like that, it's pretty easy. It doesn't really bother you that much.
But I guess, transparency and sort of being honest to your, significant other is important, because if you just think, it's just going to be this one time. No, it's not going to be this one time. This is just what it is. And there needs to be an understanding for that. And if you have kids, I guess, again, it's, do they always understand that, dad needs to be on a call, dad needs to be doing this? That's sometimes difficult. And just the other day, I was, saying to my wife that, look, she has some videos of us on vacation, many years ago. And every time, I have a look at those, it just surprises me that I'm always with my BlackBerry in my hand and just, like,
Yeah.
yeah,
Yeah.
well, it is what it is. And yeah, the good thing about, I guess, having survived it is that at a certain point in time, you can, be more master of your own destiny. But that's not always easy. And definitely that's not the position you're in early on in your career. And it's probably a lot more difficult, to do that in a big law firm where the pressure is high. That's probably why there is sort of, a retirement age forced upon you, because there is no way to continue. Actually, I'm with you completely that I would like to continue to do things. But again, don't take all the matters on, and, do it in a different way, right? Add value where you can add value, and be honest about it. Especially to your, better half. It's like, look, got to do this, and that's got an impact.
Absolutely,
Yeah.
absolutely. I mean, and she was exposed to that fairly early in our relationship. We took a trip to Europe, and I ended up having to, while we were having breakfast right on the Champs-Élysées, had to unfortunately jump on a call, which she was fine with. I mean, even from the beginning, she was fine, but I think she was kind of shocked that I was picking up this or having this particular call since I was on vacation. So I was pretty upfront right there, that which is sometimes even when you're on a trip, you gotta work. It's just part of, and the side benefit is I always tell her, well, I'm working, but at least I'm helping pay for this lovely trip. I mean, that's the other plus side. I tried to use
there is an
this is
advantage to
okay
that. Yeah.
kind of thing. So
Yeah, yeah. So if you, because we sort of talked about, the journey, what you've done, what has changed over time. If we're sort of, now look forward the next 10, 15 years, what's coming down the pike? I mean, the funny thing is you have kids that are sort of the same age as mine, 2 boys, I have 2 boys. I feel like, that new generation is quite different from our generation, and maybe also the interaction that you have between you and your kids. If I compare that with how I had my interaction with my dad, is quite different as well. Obviously, life has changed a lot. What are your thoughts on that? And if you sort of talk with them, I guess your boys, like my boys, are not on the track to become lawyers in the special sit space. I mean, it can change, everything can change, but at the moment that's not the case.
no, neither of my boys are interested in the law, practicing law. They're both, one's is biotech, bio industry, and then the other is getting his degree into business. So, it's neither interested in the law at all. Which I always thought that was interesting that they weren't interested in the law, just because both their mother and myself, my prior wife, are lawyers. So obviously they saw some things on one or both sides that they didn't like and had no interest in. And some of it may have been vacations where, I had to spend a couple hours here and there and working. I don't know. But it's just the law never appealed to either one of them for some reason. Neither one has ever explained to me why they're not interested. They're just not interested. Maybe it's a generational
No.
thing. I don't.
So did you, I mean, I think you said that one of the reasons for going into law is that you also financially wanted to, improve the situation for yourself. These days, it's, I mean, people are always asking why, right? Why are you doing? What is the why behind this? And I have to say, over time, I've come to my why. But at the age of my kids, I don't think I had, a clear why or, a very deep why. Do you have now, developed a why for what you're doing and why you're doing and being still, so happy in the special case space?
Yeah, honestly, the why is still the same. I mean, I think um, I've been lucky enough to find, maybe by accident, certainly by accident, I think that I found a career that I love. I mean, that I enjoy doing. I hope both my boys find that at a minimum, because I think if you like what you do, though challenging, that's partially I think what makes it fun for me, is that it is challenging. Um, but finding something you love is a true blessing. I mean, for lack of a better word. And all I can say is I hope they find that, Peter, that they, my younger boy in particular, I think, quick-witted, I think would be a fantastic lawyer. I've tried to I think both of them would be fantastic lawyers because they're both very, very bright. But my younger boy, he's very witty, quick-minded, and I've kind of talked to him a couple times about it. And like I said, it's just, no, not interested. No, never really given any thought to it. And I, like I said, I don't know why, other than just not interested. And so I'm not the type of father that pushes. I think I'm a big believer that they just have to find their own way on their own. The only thing I've tried to instill in them is that, you've got to make your way for yourself, but you've also got to be financially responsible too, and try to find,
Independent.
yeah, something that, that will pay the bills. Um, and I think that lesson got through, but who knows? They're both pretty frugal,
Yeah.
so knock on wood here that.
So do you think that our profession is going to stay the same with I guess everything that's going on? Obviously, everybody is or has a view on AI, but also I guess look at I think the geopolitical overlay that we have these days. Maybe more uncertainty is better for our profession because that's where we thrive. But a little bit of certainty is goes a long way, right? It can't be all uncertain. So, what are sort of your thoughts on what's going to hit our profession and how is it going to change things?
Well, I mean, you hit the nail on the head. I mean, everybody's talking about AI and ultimately how quickly AI is going to supplant a lot of professions, including ours, and how quickly that could happen. Um, maybe I'm more optimistic than others. I don't see AI supplanting what lawyers do for the most part. I think ultimately, at least I'll speak for the Bar Association in the U.S. I think courts are already putting up rules and prohibitions on related to AI, and I think lawyers by nature are self-preservationists. I think that will increase to the point where they won't let AI make us be obsolete. I think that's what they'll end up. That's where I see the AI, at least as to lawyers. As far as where our,
But if you're not using the tool, then you're gonna be outperformed by others, right? So you can't just ignore it either.
no, agreed. I don't think you can ignore it. I think it's here. It's being utilized. There's no question. I just mean I don't think the bar will ever let it fully supplant lawyers as a whole. That's all I'm getting at. But yeah, I think it'll be used. I think it'll be usable. I think it can certainly create more efficiencies in a lot of things and in a lot of areas. It's an amazing tool. It just is. No question about it. Similar to, and you mentioned the word I hadn't heard in a while, BlackBerry. Similar to BlackBerry. I
It
mean,
shows my age.
yeah, I mean, BlackBerry's changed the legal world too. I mean, before, yes, cell phones somewhat, but they really weren't prevalent until Blackberries came out, and all of a sudden you could get your emails, and then texting came shortly thereafter. But I mean, being able to get your emails on a handheld device was a complete game changer as a young lawyer, both before and after. And similarly, AI is a true game changer. You just don't see them that often. So that's what I see. It's definitely going to change the practice in a lot of ways, but I don't think it'll ever supplant lawyers as a whole, because I don't think lawyers will let it happen. I could be wrong. I could be wrong.
And what about the geopolitical sort of tensions? And the more prevalent, I guess, influence that it has. Do you think it's a temporary thing and it sort of settles itself, and it's not going to be necessarily bad for our practice, or do you think actually it's fundamentally going to change things?
I mean, I think anytime you have geopolitical issues like what's going on in Iran, it affects our practice. I mean, it just does. I mean, anytime oil is volatile, it affects how many other industries. Um, and so
Especially
yeah,
Texas.
yeah, I mean, especially in Texas. I mean, the oil and gas folks are clapping as oil skyrocketed, but how many other industries get hurt by it? So, I mean, I think it's definitely going to have an impact, especially at least in my view. It's going to have an impact, a pretty big one, because I think our economy, at least in the U.S., is already showing signs of problems. Labor, the labor market's softened quite a bit. You've still got pretty harsh inflation. So I think, I think the geopolitical climate will impact that, and it may accelerate where things are headed here in the U.S. So I think there's going to be an impact for sure. The question is the time. I think bigger question is the timing and how big of an impact.
Yeah, yeah. And do you think that the time that you've been in practice, and obviously you've been always in practice in the U.S., where, as I said, it was sort of the blueprint for a lot of other jurisdictions, where when I started, it was very much focused on liquidation, and we're sort of slowly going to rescue. And I think financial distress is still very much with something with a stigma, but a lot less so in London and New York and sort of the big places than it is in, for example, African jurisdictions. Have you seen in your day-to-day that the reputation of our profession and of financial distress and how people deal with it has changed in any way, or is it very much the same?
I mean, as to restructuring professionals, I think 25 years ago, most people would view a bankruptcy lawyer or a bankruptcy professional as not necessarily. I'm trying to think of I've heard this before, that essentially bankruptcy lawyers are like proctologists, like it's like being a proctologist. Versus a surgeon, M&A guys, the surgeon, bankruptcy is the proctology of law, which is not very flattering, but that's.
I thought it was sort of the undertaker, right?
Yeah, well, that
That's
too.
your
Yeah.
profession.
So I think again, as a young lawyer, our practice wasn't necessarily viewed, I think, by most other lawyers as a favorable practice, as something that really was as respectable as other practices. I think 25 years later, this exact opposite. I think we're specialists. We're known as specialists. Our billing rates are higher than most other practice areas. Um, there are more lawyers that come to firms interested in bankruptcy than ever before, and I think that some of that is back to the monetary side of law practice, that it's a very high dollar practice area, very lucrative practice area for firms. So I think we're viewed very differently now, and I think we're viewed as not, can't use the word expert because the state bar will have a problem, but I think we're viewed as specialists and truly as a practice area that has a very good niche, not a bad niche like it used to. And I think that's a big change over.
But we're actually, yeah, so we're specialized. We're almost like a specialized generalist, right?
Definitely.
Because we're coming across almost all, areas of law practice, but in a certain, I guess, flavor. It's the financial distress flavor that's on top of it. And that changes, what normally is the case when the sun shines, when it starts, clouding over and starting to rain. Everything looks different, right? But it's the same sort of practice areas we come across. And that's why, I guess, going back to your point, it's never the same. It's never boring. That's why, right? Because it's just not one thing you need to do. It's everything that you see in a certain light.
I could not agree more with you, Peter. I mean, that's exactly what we are. We are specialist generalists. I mean, you do touch on, again, bankruptcy has, at least in the U.S., has a code. It has a very specific procedural process and mechanisms, but it does not impact what the substantive underlying law, whatever industry you're in, that's governed by each state's law. So that's why I say oil and gas case is very different if it's based on Texas law or Oklahoma law or Wyoming law. It's always something different. And to your point, the fact that it's a generalist specialist practice and truly is a hybrid practice. People always ask me, are you more of a litigator or more of a transactional guy? I'm like, well, both. I mean, we end up doing asset sales. So you're doing M&A or involved in M&A processes. You are drafting very detailed plans of reorganization. So you're the transactional person. But when you go to court, you're the litigator. So it's a very much a hybrid mixed practice, which again is part of the reason I fell in love with it to begin with. Was, I like the order, the procedural aspect of bankruptcy and not practicing Wild Wild West, but I also love the fact that just knowing the code and being familiar with the code doesn't necessarily get you even close to all the way there on the legal issues in any specific case, because that's governed by a whole different set of laws.
Yeah. And, maybe just sort of, having an overview of the career you had so far. Was this all planned? And sort of, you had certain goals and you wanted to achieve them, or is it a lot more fluid?
Oh, I wish I could say I had a plan. No, I mean, if you had told me that I would end up living in Texas when I was heading even to Tulane, I would have thought you'd need to have your head examined. If you had told me I'd be a bankruptcy lawyer, again, I'd be like, you're crazy. Why would I ever go to that type of practice? Or, be fortunate enough to do some of the things I did. No, I many times I would consider myself very, very lucky. I didn't have a plan. I didn't go to law school planning to be a judicial law clerk. I didn't, or anything. I just was very fortunate to have that opportunity. In particular, I was lucky to have that opportunity.
And is it, so how does it work then? You have an open mind and you just, if an opportunity comes along, you have the guts to sort of go for it, and you have no restraints. How do you sort of, seize upon opportunities if they come across your path? Because that's sort of, the questions you usually get, right? Is, well, was this all planned? If not, okay, how did it work? How did you get there? What do I need to do? Were there a lot of mentors along the way that sort of helped me out? I mean, Mickey Sheinfeld, you already sort of mentioned he was a big mentor that helped you out. But okay, how does somebody become a mentor? It's just also a little bit of chemistry that needs to be there. And maybe, being the right person at the right time, a little bit of luck.
Yeah, I mean, definitely having mentors and people along the line to help guide me were critical. I mean, absolutely true. I was about to get in, and Mickey was one of my main mentors in my early career. One of my other mentors, I was lucky enough to extern for a federal judge during law school. A gentleman, amazing man by the name of Honorable Louis Moore, who has passed, but he was. Like myself, he grew up working class, poor, wasn't really Didn't have any family members who were lawyers or anything like that. And I mean, he gave me a lot of confidence and a lot of like practical advice during my law school career. The only thing I had planned was to go to law school and try to finish, which was touch and go many times because of money issues. I mean, I had to borrow a lot to do it. I didn't, my family couldn't help me financially. So, I mean, it was just finishing was my only real goal when I went. I really wasn't, I got to make law review or I got to do this or I need to get a federal clerkship. It was, I didn't even know enough about how to practice law at that point to even know what some of those things were. And so,
Do you think that actually having experienced financial distress yourself, in the sense that there wasn't much money around, did that help you in becoming, I guess, the special sits lawyer that you are? Because there's part of it is also having some empathy and some understanding of, I guess, the sort of stresses that go along with financial distress.
Absolutely. And I think that has an impact on me, and how I handle things with my clients because, I've been in a lot of their shoes, the companies. I mean, I've seen the situation where your liquidity and your pride, I mean, a lot of these smaller businesses, especially, I mean, this is their pride and joy. They've owned it for 20 years. They've started it, and to see it struggle, oftentimes through no fault of their own. I mean, I've got one right now where we're trying to do an out of court restructuring. It's a oil and gas related entity, and the gentleman's owned the company for 30 years, but there's so much uncertainty in the oil and gas market that his business has dried up. And so, it's not his fault. It's just the geopolitical climate has created a lot of issues, I mean, notwithstanding the recent increase in prices, but has created a lot of issues with E&P companies and what they're spending to drill here in Texas. And so, yeah, that background, I think sometimes is helpful because I can relate a little bit to the situation. And I mean, sometimes when you're dealing with folks that are going through that, you're not just the lawyer, you're a true advisor. I mean, you're really a counselor,
Yeah.
and not just on legal issues. Sometimes it's keep your head up. This is unfortunately, we're looking at bankruptcy, but it's happened to a lot of people. A lot of companies have had to go
Yeah.
route. Don't take it too harshly. So it's a hard conversation to have with people. Understandably so, but
Yeah.
sometimes you have to. So I do kind of, to your point, sometimes view, especially if I'm representing debtors, I do view part of my job is to just talk to them and understand what they're
Yeah.
going through on a personal level, because it's difficult, really difficult.
And I guess you also running your own business at various points in time is, again, an added way of connecting with people that you counsel.
Yeah, absolutely. Because you know as well. I mean, bankruptcy is restructuring work is cyclical. I mean, you definitely have times where you're super busy, and then there are some times where it's just not all that busy out there. I mean, to that point, I'll never forget the 2020. At the beginning of the pandemic, I mean, we were probably the first 9 months of that year, we were the busiest we'd ever been at our firm. I mean, we had multiple debtor cases. Everybody was just in havoc. I mean, well, I'm sure it was same for you, but what was amazing was here in the States, they created the PPP loan program to basically help companies get through this process. And the minute they started issuing checks, I mean, our work just dried up overnight.
Yeah, buyback loans here, the same thing. All of a sudden, the financial distress was taken care of, and people that should have been, in problems were no longer.
Right. And
I guess, on top of that, now you see a lot of like fraud that was associated with the buyback loans. And,
definitely,
there's
definitely.
various cases of people being disqualified because they just got these loans because the threshold was very low and you could get the money. And yeah, there's always people that are devious, right?
No, absolutely. And the only reason I tell that story is because it guys kind of goes to your point, which is, I mean, our business can be blowing and going 1 minute, and then all of a sudden it's nothing there. So I can relate to what, through no fault of my own. It was just that's the program they did. They put money back in companies that were struggling's pockets, and also kind of told the banks to stop foreclosure, which is obviously a big basis reason why companies often have to file is because the banks are issuing or seeking to foreclose on assets, whether that's via real estate or equipment or whatnot. They stopped doing that around the same time. They just, I mean, the first time in my career I was getting forbearances from banks on clients for no money, no nothing, just here you go. Well, we're going to kick the can down the road 6 months, which was great for the clients, and I was happy, but at the same time, the work dried up. So yeah, I mean, luckily we had enough to keep us going. It wasn't like we completely evaporated, but we went from big business, real steady business to very little for about a good 8 or 9 months. So I can relate. From a business perspective, back to your question, but from a business perspective, I can relate where sometimes your business just doesn't go the way you want it to through no fault of your own. It's just the practice slowed down, the work slowed down, and you had to make tough decisions. So.
Yeah. So have you, because for me, my career has been, privately and professionally both been quite international, right? I mean, for you, it's been also within the US. You've moved to different states, and almost like that's to a certain extent a different country in many ways. I mean, for London, it
Yeah.
is, for people outside of London, London is a foreign territory, right? But I came from the Netherlands. Obviously, it's a different country and what have you. Uh, the fact that you see, different people, different cultures, different, countries, in my mind, is also a big part of the development of me as a special sits lawyer. Is that something that, you had in your own way as well? Don't stick to, I guess, where you grew up and sort of don't venture out. I mean, it's almost impossible these days not to venture out with all the, I guess, technology that we have. But there is no proxy for actually meeting people, in the flesh, and traveling around at times, business wise or or personally.
I mean, look, absolutely. I think, I've been fortunate to travel a lot. And that is part of the reason why I have enjoyed my career at a small firm because you do have a lot more flexibility to travel. And it's an interesting question. I hadn't thought about that, about whether travel had ever impacted my career or my thought process on restructuring. I don't know the answer to that. I've never really thought about that, but I have to imagine that some of the travel has impacted that. It probably is more under the surface than overt. But I think travel, I didn't travel much as a kid. I really didn't start traveling until my career was well underway. So I mean, I didn't have a lot of experience traveling before I became a lawyer. So it's I mean, I think I'd never been to Mexico. I'd been to Canada a few times because it was so close, but never been overseas. Never been to Central America or traveled in the Caribbean or anything. Um, so yeah, I got to imagine. I mean,
To me, it's sort of back to your point earlier, is that ultimately, we're trying to resolve issues. We're trying to sort of, compromise things in a way that we're not trying to win all the time at the expense of everybody else. And the more sort of players that are around the table, the more dynamics, cultural backgrounds, motivations you have. And if you've somehow experienced and can relate to where people come from, it helps you. And I guess traveling and seeing different parts of the same country or different countries and different cultures, in my mind, helps get that understanding and that open mind that you also need to resolve issues in financial distress.
I mean, absolutely. Like I said, I hadn't really thought about it before, Peter, but I think you're absolutely right. I mean, I think that I think that travel opens up your mind for a lot of things. Like I said, I hadn't really thought of it in the context of career and how that might have impacted my thought process and all of that in the restructuring world, but it certainly has impacted me personally. I mean, because back to my wife for a second, but we both love to travel. We both love to talk to people. We like to do local stuff. We don't, we do some of the tourist stuff as you would expect, but we end up spending more of our time just wandering around and walking around and getting to see smaller things and meeting people and talking to people. And there's no question that that opens up your mind to understanding other people's perspective. And I agree. I don't think it has to be international travel. I think just, going from a small town to a big city and getting a big city's perspective versus a small town perspective, it can be very eye-opening from either direction. Getting involved with people from different cultures and different religions oftentimes is to me an amazing way, and has been an amazing way to learn more about people in general and how they think, how they process the different facets of life. So yeah, it's like I said, you're gonna make me think now about this issue of how travel has impacted
Well,
me.
look, it is,
Just
because I
never
guess
thought about
we're
that.
at a time where we can reflect on things, and especially also what you're saying about, I grew up in the countryside, very small community, and then moved to study in the city, then obviously moved to London, one of the world cities. I mean, yeah, all of these things are huge changes. But again, if you just go with the flow, open up your mind, and let the experience sort of enrich you, it helps you in many ways, I think.
I could not agree more. I mean, I fundamentally, like I said, it's absolutely impacted the way I view the world, the way I think about things. Certainly on a personal level, like I said, I just you brought up something I had never thought about before. Honestly, I just never thought about how that may have impacted me as a restructuring lawyer. Really had not. It just
Yeah.
never occurred to me. So thank you for keeping. I'm going to thank you at 2 a.m. keeping me
Well, that's something to think.
in
So,
line.
do you have for yourself, or maybe for the profession, a life philosophy that you sort of stick by?
I've always been a work hard, play hard guy. I guess that's what my philosophy is, work hard, play hard. I think enjoy life. I try to enjoy life as much as I can. It's short. And, you know, that is one of the reasons why I work for myself is I have more control over my daily life. And yeah, so I mean, really, I think that's really my philosophy. I also, my parents were always of the mind that, treat everyone the way you want to be treated. So I try to treat people with kindness, even when I'm disagreeing with them, and respect, no matter whether you're the CEO or the, uh, person mopping the floor. Because my dad was the guy
Yeah.
mopping the floor for many years. So working 3 jobs to make things happen. So I think respect for other people is a big part of, I think, how I would generally view myself. At least I try to have that respect and kindness for others.
Yeah. Look, really appreciate sort of you sharing these thoughts with me. Maybe one last question, which I sort of ask everybody on the podcast. If younger people look at this, they want to sort of maybe start a career in special sits, be it a lawyer, be it a banker, a financial advisor. What would be your advice to them?
Well, I mean, well, first of all, thank you for having me on. Obviously you and I have been friends a long time, probably a lot longer than either of us wants to admit. But um, again, it goes fast. It goes fast. I feel like we blinked and 20 years went by. So I don't know. My advice, is really look into it. I mean, it's a fascinating practice. It really is. If you are the type of person that likes puzzles, that likes to be challenged, it's a great practice area. If it's going to be stressful, it's going to be fast paced. But if you're the type of person that likes that type of, adrenaline, and likes the challenges that go with restructuring, I my advice is take a look at it. I mean, go take an internship. Talk to somebody like Peter or myself, who have done it for a long time, and why we enjoy it. Ask questions. I mean, that's I think the advice I always have for my sons, which is ask questions. If you don't understand something, ask questions. See what somebody who's been doing it thinks, and then figure out whether you're in parallel to that. I mean, that's my advice really, is look at different things. I mean, don't be afraid to ask somebody a question. I mean, I used to think, oh, I don't want to bother somebody. Little secret.
Yep.
We love talking to. I love talking to young lawyers. I love giving it. Trying to, if I can steer them and be a mentor, like so many have been for me over my career. I mean, one person, by the way, I forgot to mention. We were talking about mentors. One of my main mentors at our former firm, Lisa Beckerman, Judge Beck, who's now a judge in New York. She was one of the best mentors you could ever have. She was an amazing lawyer. And she always amazed me because, and back to another question you asked me, what are the best types of bankruptcy lawyers? Judge Beckerman was exactly that type, where she didn't just understand the law. She had an MBA, so she knew financial statements better than some of the FAs involved. She was in some of the cases. She was absolutely amazing and an amazing mentor. But ask questions. That's my advice. Don't ever be afraid to, if you're trying to look into a career, to call somebody like Peter or call somebody like me or call somebody who's a financial side of things and get background information for how that. Lawyers in my experience are almost always willing to sit down for a cup of coffee or jump on a phone call or a video call and answer any questions you have. I've had tremendous value over my career in just asking questions of colleagues and friends. What do you think about this? Where do you think this is headed? All that. You learn more by asking questions and listening than you do by talking.
I agree, and Lisa Beckerman, obviously, she was also one of the trailblazing women in the space. That sort of, probably even more difficult to, be as successful as she was. She, remember her also very fondly, and very, full on, intense, knows her stuff, and did a lot.
Absolutely tough negotiator, but knew how to cut a deal. Absolutely. I mean, that's another thing. And, to that point about more women in the restructuring world, I mean, I'm sure, I assume it's similar for you, but 25 years ago, not very many women in restructuring, both either in the legal side or in the financial world. Now it's tremendous to see how much that has grown. I mean, I think men still outnumber women pretty dramatically in our field, but there's a lot of diversity now in our practice that was not there 25 years ago, which is on all levels, which is really great to see, because I think that
Yeah,
is
and extending to that, so it's not only just gender, but it's not just only uh, uh, people from the West. It's in our cross-border insolvency space in particular, and special sits. It's with all different backgrounds, all different areas, which is one of the things I so enjoy about being a cross-border insolvency lawyer. The fact that you're coming across different cultures, different people, and different local circumstances, and you need to, as you said, there's a puzzle you need to resolve, right? And you may have experiences yourself, but you can't sort of copy paste them necessarily all the time somewhere else. You need to have an open mind for local circumstances. And yeah, it is growing. Brian, I'm sure we could easily spend, a couple of more hours talking and going various avenues. I've been already sort of, taking up a lot of your time. I really appreciate it. Well, thanks again for speaking with me.
No, thoroughly enjoyed it. And I hope to get over to London to go back to your club at some point. which was wonderful. So,
Oh, well, that's a deal. We'll do that. I will
all right.
definitely be over,
Good to see you, sir.
in Houston.
Great to see you.
All right.
All right.
See
Take
ya.
care now. Bye-bye.
Bye.